So with that, I'm going to go ahead and get us started for today. This is Pedaling Toward Progress, Understanding FAPE Through Legal Frameworks and Lessons Learned from the Field. And this webinar is brought to you by the Progress Center. The Progress Center is a federally funded technical assistance center. We provide resources and tools and technical assistance and support freely available to you all in the field. Our work is really bucketed into three main items. Our first area is really focused on understanding the research, policies, guidelines, learning from the field, parents, educators, stakeholders, and others doing the work to really understand what works for students to improve outcomes for students with disabilities. Our second phase of work is really working at the local level with a select group of schools and districts, really intentionally about focusing on that high quality instructional programming or educational programming. Really, what does it take to design and deliver that programming, testing out tools and resources and working intentionally with folks over time and partnership sites to really learn alongside with them. And the work that I get to lead is the final bucket here. That's providing all our freely available tools, resources, materials, everything you can find on our website. Feel free to take, use, adapt those for your purposes as you go forward. All of that material is there on the website at promotingprogress.org, so you can explore that to learn a lot more about the center and all of the work that we're doing. And with that, I'm excited to turn it over to our two wonderful presenters for today. We have our Progress Center Director, Dr. Tessie Bailey, as well as one of our Progress Center advisors, Dr. Perry Zirkel. So we're very grateful to have both their expertise on the line today to really talk through these kind of key lessons learned from the field, as well as what we know from the legal considerations and frameworks.
Thanks, Amy. I'm excited to be here. We are closing up our first 5 years of the Progress Center, and we have learned a lot. We've navigated COVID, really sort of moved the way that we think about supporting students with disabilities. And we're excited to share what we've learned, as well as sort of establish the legal framework for those of you who are working in this the settings right now. Throughout today's session, we're really going to be talking about these three sort of faces of FAPE. And if you think about the way we do work, we stay a lot in this procedural aspect, and it's more of like in the development of the IEP, are we really complying with the procedures that have been set forth by IDEA? It has sort of guided a lot of our work for the last couple of decades. But what we have also found is that this procedural piece really only gives us a small piece of what we need to be providing for FAPE. Today, we're going to talk a lot about the substantive requirements that really was refined through the Andrew F. decision, Supreme Court decision. And this is thinking about how do we put all of those procedural requirements together to create an IEP that's reasonably calculated to actually promote progress for the student. And now what we're also seeing, I think in the last decade or so, is this other dimension or face around implementation. And it's not that just we identify and develop an IEP, but that we implement it in a way that actually leads to that growth that we were expecting for the student. Now, over the last 5 years, we've developed some resources, and one of those is the video I'm about to show you. But it helps, I think, educators, leaders, family members really understand how these sort of faces of FAPE come together to really promote progress for students with disabilities.
School and post-school success for students with disabilities depends on the development and implementation of a high-quality individualized education program, or an IEP. The IEP's development and implementation are comparable to the design and use of a bicycle. Bicycles are made up of individual parts, but it is only useful as a bike when all the parts seamlessly fit together. Similarly, an IEP is composed of required parts that, when aligned to each other, create an individualized program or vehicle that allows students with disabilities to make progress. The Individuals with Disabilities Education Act, or IDEA, outlines 7 required components or parts of a procedurally compliant IEP. Similar to a bike, which requires a frame, wheels, handlebars, seat, pedals, brakes, and chain, an IEP must include a present level of academic achievement and functional performance, PLAF statement, measurable annual goals, a monitoring plan, statement of special education and services and aids, an explanation of the student's participation outside regular education and in state and district-wide assessments, and the date, frequency, duration, and location of services. Unfortunately, many educators and service providers focus on the development of individual components or parts of the IEP found in their IEP form or template. This can lead to what many believe is a compliant IEP that cannot be feasibly implemented or is not likely to promote progress. Focusing on the IEP components in isolation can devalue the IEP as a valuable tool and place compliance as the end result. It would be like buying expensive bike parts that do not fit together. What makes the bicycle functional is when all its parts fit together or align so that it can be ridden. It's the collection of the aligned parts that provides us with a well-designed bicycle. Ensuring all the parts of a bike fit together is very similar to ensuring the required parts of an IEP fit together. In well-developed IEPs, there is a direct relationship between the PLAF statement and the other components of the IEP. Ensuring the parts of the IEP fit together to demonstrate internal consistency allows IEP teams to address both the procedural and substantive requirements of providing students with disabilities a free, appropriate public education. Well-designed IEPs are also easier to implement and more likely to lead to improved academic and functional outcomes. The PLAF statement is the foundation of the IEP that documents the student's needs and baseline for measurable annual goals that are necessary to support the student in accessing and progressing in the general curriculum. A well-designed PLAF statement also justifies the proposed services and aids, including specially designed instruction and classroom accommodations and supports that are reasonably calculated to help the student progress on annual IEP goals and on state and district-wide assessments. Although bikes have similar components, not all bicycles are the same. Some are designed for the Tour de France, while others for going on a picnic or to the beach. There is no wrong bicycle, assuming the parts work together to meet the unique needs of that user. IEPs are very similar. They all have the same required components, but are designed to meet the unique needs of the student. How do we know if the IEP meets the student's needs? For each annual goal, the IEP team develops a description of how the student's progress towards the goal will be measured, which is shared with parents and families. When implemented with fidelity, the monitoring plan provides data that the IEP team can use to determine whether the IEP is reasonably calculated to promote appropriate progress for the student. In some cases, the student's circumstances and needs change, and the IEP team, which includes the family and student, when appropriate, may need to make changes to the proposed aids and services. Remember, the IEP is not the outcome. It is the vehicle through which we can support students with disabilities in achieving school and post-school goals. Just like a well-maintained bicycle helps us navigate various terrains, an IEP that is implemented with fidelity and uses ongoing data to monitor its impact can help a student overcome obstacles and make meaningful progress. A well-developed and implemented IEP can ensure students with disabilities are able to access and benefit from school and post-school opportunities alongside their peers.
So this video was created just, I think, through our collaboration with local educators, as Amy mentioned at the very beginning, to help sort of make sense about the procedural aspect and the substantive aspect of the IEP. This video is available for you, and Amy will put the link in the chat box, but it just sort of illustrates it towards a bike, which I think makes more sense to a lot of folks. So the purpose of our session today is to really dive into the legal requirements of the phases of FAPE that we talked about. Now, as Perry will mention, the legal requirements tend to be sort of that minimum or lowest bar level that helps us understand our obligations under IDEA. And then I'm going to follow up with some of the professional recommendations that come from the literature and what we're learning from our local educators about what works and what doesn't work. pass this to you, Perry.
If we can go back to that slide before just for a second, thank you. Both Tessie and I, as well as this slide, show the duality that we're trying to convey to you. I, if we analogize here, am personifying the legal side. And that is, as Tessie said, just a basic minimum. It would be as if the bike were challenged in court as not meeting the required components and its sort of fit. And a court, which makes that decision, doesn't have the expertise and the nuance that most of you have. And thus it relies on doctrines like precedent and statutory interpretation to come up with just sort of what's the minimum requirements for this bike. But whether this bike really works for this kid and whether it's implemented with fidelity is more a matter not of me, but rather Tessie, symbolizing here evidence-based best practices according to professional norms. I'm sort of the dark and dank basement of the shall or must. Most of you, along with Tessie, operate at a higher level that you don't want to confuse with the basement. You're doing the should, and you're working on collaboration and trust, whereas the law is in the other direction. And if you're successful at your level and do not confuse or lower yourself to my level, you are more likely to achieve effective collaboration and progress for the child. Now, when we move within my sort of basement or minimum area, you find that the courts, again, and we look to the courts as sort of a leading edge of the law, the courts have developed sort of three categories from their perspective or lens. As mentioned in an earlier slide by Tessie, procedural, substantive, and implementation. And a sort of standard or test or analysis for adjudicative purposes has developed for each one. So we start with the procedural side of FAPE. And that, by the way, is no coincidence for two reasons. One, chronologically, the first Supreme Court decision that addressed FAPE was Rowley back in 1982. And it focused more on the procedural side, although it started with it started with sketching out a substantive standard that then became clearer when we got to Andrew F. The second reason that it's not coincidental is that courts, unlike most of you, through their lens, tend to be much more procedural. If you are a judge and you are a generalist and you are dealing with all sorts of cases from serial rapists and murderers and white-collar crime and political issues, etc., and then you visit the area of special education, which is so relatively nuanced and limited compared to some of these other big areas, courts orient themselves to the procedures because that's what they're good at, and procedures don't require particular expertise. And so focused in on procedural FAPE, we end up, and we're looking at the second bullet on this slide, and notice that it starts with, for the adjudicative route, adjudicative being a big multi-syllable word, but purposely used there because it includes under the IDEA, first, a due process hearing, second, in at least 7 states currently, including New York, which is the most litigious, a second administrative tier of a review officer. And then we go into the 3 levels of court. And at the federal level, where most of the cases end up, we start with the federal district court, we then go to the regional court of appeals, and on an occasional case, only about 12 to 15 cases in the 50 years or so under the IDEA, we reach the Supreme Court. And so when I say adjudicative route, at any one of those levels, what Congress has codified in the 2004 amendments of the IDEA, which are the last amendments of the IDEA. If you look at the second bullet, you find these sort of adjudicative test or analysis. A hearing officer must find one, that is, if I think of two steps. So first step, was there a violation? But if there was a violation, which most of you think of in terms of compliance, a court goes to a second step and makes it that much harder for a parent to win because there's a second hurdle. And that is to prove that the violation resulted either in a substantive loss to the child, which will bring us to substantive FAPE, or sticking with the procedural side, remembering that parents have not only the right to represent their child up until age 18, but also that parents have their own independent rights for participation, meaningful participation under the IDA. So did the violation result in a loss to the student or to the parent? If so, that's a denial of FAPE, and that will cause a remedy as well as a parent becoming prevailing for possible attorney's fees. But notice that that two-step test in court is different from what we'll see in other arenas. Now, if we stick with courts, I had done a study with a colleague back in 2017, which looked at a 10-year period of court decisions specific to the IEP process, including the IEP components, these sort of bike parts, the team, the separate regulations for other parental participation, and finally, the development, effectuation, and revision of the IEP. And what I found at the time, for a 10-year period ending in 2015, that parents won less than 1/4 of the cases that went all the way to a decision. Now, of course, we always have the hidden side of settlements, but parents had a hard time winning those cases because in many cases, the majority of the cases, they weren't able to show that second step loss. And I recently, right now, I'm engaged in an update, and I've looked at the 9.3 years since July of 2015, and I'm finding reaffirmation, confirmation of the same findings of this two-step test within judicial adjudication. Going to the next slide. However, remember, as you see the visual of these three arrows on this slide, that the adjudicative route is only one route that parents or districts can file for, and that leads to ultimately judicial precedent. But look at the second and third arrows, and thus for those of you in the field who are thinking about legal minimum, what gets a little bit more complex is we're focusing on the adjudicative arrow, if you will, but the state complaint process, depending on the particular state, but in general tends to be more strict about procedure and doesn't always look at that second step of whether it resulted in loss to the student or the parents, just simply that there was a violation that's out of compliance and there may well be corrective action. And by the way, for that arrow, not only parents, but anyone can file a state complaint, whether you're a retired professor or a grandparent or just a visitor to a particular school. You can file a complaint and there will be an obligation for the state to investigate and issue a decision within 60 days. And finally, many of you deal with the monitoring process, the bottom arrow, before we leave. We'll go back that slide 12 for a second. And that is that, again, there's variation from state to state. But what I had to tell you about that two-part test does not necessarily apply to the priorities and the orientation of that particular state education monitoring process that's mandated by Congress. Then we go to slide 13. We're back to the adjudicative route. And one of the reasons we focus here is because it's the case law that sort of sets the precedent. And this is the sort of most costly, time-consuming process that when you get caught in it, it's obviously both in terms of resources, time, emotions, and economic costs, the one that is the most high stakes. And so I've just selected for you, somewhat randomly, 4 relatively recent cases from around the country to illustrate the application of the 2-part test. We'll have to go through it fairly quickly, but there are more details that you can get into if you're interested by going to either the modules on the Progress Center website and or my own website, where I've now on a retired basis try to share my publications, research, and a monthly update. So REB, a 9th Circuit case, the several states in the far west, including Hawaii. And in this case, the parent argued, remember, step 1 is, was there a violation? And mom says, you didn't specify who or what the credentials or qualifications were for my child's aide. And the 9th Circuit ended up sort of looking, remember that we're in the basement, they just look at the law, they don't look at sort of what may be best for this child or parent. And they just said, remember those bike parts, there was not one of those parts that said you had to specify the qualifications of the aide. You had to specify a statement of special ed and related services, but not getting into the nitty-gritty of the qualifications of the aide. So parent lost that case at step 1A, if you will. Capistrano, another 9th Circuit case, the second one listed here. Goals. Now, if you look at professional training and expectations on measurable goals, you'll find that the general consensus within the profession is that measurable means sort of quantifiable, objective indicators. Yet courts, again, are used to subjective judgments, and they concluded that these goals that you might not, as a professional, find to be sufficiently measurable met the test, because whether they're objective or subjective, according to the court, they reasonably conveyed where you were aiming to go. Third and most recent case here, a 3rd Circuit case, which is New Jersey, Delaware, and Pennsylvania. Here, because it was a Pennsylvania case, Pennsylvania is relatively unusual in that we're one of only 2 or 3 states that require an FBA or BIP for learning impeding behavior. And the court said that this school district didn't meet that state law requirement, and thus it was a procedural violation. And for this particular child, the lack of an FBA BIP was not compensated for by other behavioral provisions and requisite progress of this child. And so the parent won big in this case in terms of reimbursement or compensatory ed plus attorney's fees. And finally, Preciado, a federal district court of New Mexico case, ruled that the district's failure to explain what I'm calling an obscure progress tool, which some of you may well use and buy as one of these software presentations, the court ended up concluding that neither this parent, who didn't have a high school education, much less the federal judge, who obviously has a law degree, found all of the acronyms and what the court regarded as sort of gibberish as not being meaningful in terms of a measurable goal and resulting in loss of meaningful parent participation. So you see a variety of results, but they all use that same adjudicative 2-part test. Next slide.
So sort of, thinking about this procedural part, as Perry mentioned from the bike, we as professionals often think about our PD in relationship to those individual parts. I'm sure you took an IEP course in college, and it was really focused on how to write these specific things. Now that's really important because we want to be able to detail out some of the present level needs. We have some clarity about what needs to be there. We want to make sure that we're documenting the statement of services and aids. We want to have annual goals that can be measured in a reasonable way. But I think what we're finding is, and some of you have mentioned this to us in some of our work, that sometimes we have a little bit of an overfocus on compliance. And as Perry mentioned, this compliance does give us some framework or some boundaries about how we do our work. But how we do it is probably not as important about why we need to do it. So some of the professional recommendations that we're finding in the literature and from our 5 years of iterative work with local education agencies is that if we build the competence and confidence of the IEP team members, including families, about what are those requirements. So not necessarily how to do them, but what are they and why are those procedural requirements there? We see better adherence to them because they see value in them, and they also see that following those procedural requirements leads to a much more substantively appropriate IEP and actually aids in the implementation of those services. A much more strategic thing that we've also found is that when IEP team members develop the present level statement, which we'll refer to here as a PLAF statement, which is a present level of academic achievement and functional performance, if they collectively develop that, and collectively meaning the IEP team members are part of it, including the family member, they've documented a holistic statement about the student's needs, and that is shared prior to the development of the IEP and the IEP team meeting. We have much more robust conversations, as Perry mentioned, trust with families, because now everybody's coming with the big picture of the child's needs. Too often, because of time, we're coming into meetings with just our perception. If I'm a related service provider, I give you my tiny statement. If I'm a special ed teacher, I give you my statement. And the regs make it clear it's a single statement. It's one sort of written picture of this child's needs. And if we're all in agreement and all aware of those, then we are more likely to create a more appropriate IEP. And finally, this last one is that, as the team is developing those components, we need to focus on what the child needs. We have seen a shift in the IEP development where we're trying to put in everything that the teacher or the school is going to do. It goes back to that case that Perry was mentioning about the qualifications of the aid. We don't need to put in all the nitty-gritty details about what we're going to do. What we need to focus the IEP on is what the child needs in order to make progress towards their annual goals and access and progress in the general curriculum. There are a number of free resources, and Amy will put these in the chat box that you can use and customize for your local audiences around what are those procedural requirements in terms of meaningful engagement of families, as well as those IEP components. I think where we've seen our greatest success in meeting those procedural requirements, as Perry mentioned, that second bullet is about how do we meaningfully engage families? When we provide a draft IEP, it could be perceived as predetermination. And so when we develop that PLAF prior to the IEP meeting, folks are coming to the meeting with a very clear picture of the child's needs. The family knows how to participate. We have a much more meaningful IEP meeting and a more substantively appropriate IEP that results.
Now we're moving to the second face of FAPE, which obviously overlaps. These are not all mutually exclusive, because if you remember from the two-step test for procedural FAPE, one of the two options was a loss of substantive progress or a substantive loss to the child. And that then triggers either as part of a procedural FAPE claim or as a entirely separate claim, the claim that, hey, you may have all the parts of this bike, but it's not working for my kid. My kid needs a lower seat, and my kid needs two wheels in the back, etc. And so how good does the bike have to be, again, to meet the legal minimum, which is not the sort of should that you share with parents in terms of your mutual commitment to do the best you can for the child. But again, looking back at just what the minimum is, we find Andrew F. in 217 revised or refined the Rowley sketchy substantive standard. And in my view, and this is just my own personal view, because as you'll see in a minute, when we look at this language, it can be interpreted many different ways. But in my view, if one reads fairly impartially or objectively, first Rowley and then Andrew F., one gets the feeling that regardless of whether the court is particularly liberal or conservative, that all the judges seem to agree that the IDA, one, is largely procedural, partially because judges tend to look at the world that way, and two, that because it's largely procedural and it sort of assumes that if you align all the bike parts and customize it to the child, it will generally work. The substantive standard of sort of how fast and how far the bike has to go is relatively relaxed and somewhat amorphous. So Rowley said that the IEP must, again, remember that we're at the minimum, so it's must or shall, must be reasonably calculated. Now, watch the language that you can see on this slide. That, wait a minute, go back to that slide for me. Yeah, thank you. I'm going to recite Rowley. You see Andrew, so you can see the change. So Rowley said the IEP must be reasonably calculated to enable the child to get or make, and it said educational benefit, but it didn't say how much benefit, whether it had to be some benefit or meaningful benefit. Andrew sort of ducked that question by not adopting some or meaningful, even though the circuits had split previous to Andrew in those two directions. And instead, one, changed the word benefit to progress, and two, for the adjective, how much, put the adjective after progress and said appropriate in light of the child's circumstances. And this, again, can be read different ways by different people. But when we move to the next slide and start looking at the case law, before we get to the case law, by the way, there's a little more in Andrew F. That's not what we call the holding or the gist of the case, the rule of the case, but some corollary commentary. It ends up talking about the first bullet, talking about essentially Amy Rowley, because Andrew F. is looking back at the range of children and adopting from Amy Rowley that when a child is fully integrated in the regular classroom, and that, of course, implicates the notion of LRE, what FAPE means is providing a level of instruction reasonably calculated. Now, what did they classify educational benefit as? And now appropriate progress. Advancement through the general curriculum as measured typically by one, grades, and two, promotion. But Andrew is not like Amy Rowley. He was not fully integrated. He was in a separate special education class for children with autism. And if you look at what the court says in the second bullet, it's sort of, if I were Andrew's parents, I'd be somewhat insulted if you're putting my child there, but the court sort of is classifying two extremes, not necessarily saying Andrew is at this second extreme, could be in between the two bullets. But if the child is not fully integrated and here's the insulting part, not able to achieve on grade level in terms of overall capacity, whatever that might be, or potential, his or her IEP need not aim for grade level advancement, that is promotion, but must be appropriately ambitious, and you see here challenging objectives. My point here is that if you read this case carefully, as many do not, including some lower courts, you will find that the notion of ambitious goals and challenging objectives does not mean what we normally mean by ambitious or challenging. It's saying ambitious in comparison to not quite being promoted or getting passing grades. But again, that's just an interpretive nuance. Now we get to the lower court case law. And this sample is fairly representative. And what I found in general is that the post-Andrew F. court decisions do not significantly differ in their outcome distribution from the pre-Andrew F. cases that had arisen under Rowley. To courts, at least, it doesn't seem operationally that we're getting the significant elevation that many of us had either hoped for or had read into Andrew F. Here's an Eighth Circuit case from the Midwest, and Eighth Circuit is a high level. We have a child with multiple disabilities, and the court ended up concluding, contrary to the parent's claim, that this kid's IEP met the Andrew F. standard because its provisions reasonably were calculated to address his learning impeding behavioral difficulties, even though, as a matter of best practice, we might well have expected, and this child, again, watch the word, should have had an FBA BIP. Now, compare this case to the earlier Pennsylvania case. That one was within an unusual state law that required it, but the IDEA, when read objectively, does not require an FBA or BIP. It just requires consideration of strategies, including positive strategies, to address that behavior if it's learning impeding. Second case here, another high-level court in recent years. There's GD versus Swampscott Public Schools, an IEP for a second grader with severe dyslexia that resulted in slow gains based upon, now again, teacher judgment. And again, that is clearly questionable in terms of subjectivity and sort of the adversarial process as to whose side that witness is on. And when we look at a more objective standard, no gains on standardized testing, according to the factual findings in the case. And yet, the parent lost this case because, again, depending upon the interpretation, what is reasonably calculated for this child with severe dyslexia will depend upon the child, but also who's the judge or judges and who are the attorneys that make the arguments as well as the witnesses. On the other hand, Asio, the third case here, shows a clear parent victory. And some of you in your professional lenses might have disagreed with the court and been, in terms of best practice or the should or norms may be correct. Here, it may be in reverse. Here you had a child who was given a full school day with an IEP for this school day that was addressing his needs, but he had a rare form of epilepsy where the severe seizures were so severe and so frequent and happened to cluster each morning that this child just simply could not safely attend school and access education. Thus, the parents said it would be substantive FAPE reasonably calculated if you gave my child, who starts the school day at 12 o'clock, thank you very much for being flexible enough, but if the day ends at 3, give my child a break to come home and unwind, as most children do, and then maybe from, let's say, 4 to 6, give my child some one-on-one specialized instruction to implement his IEP so that he gets the full opportunity. Well, many school officials said, we're not going to go down that road. We gave you the sort of the water. You've got to come to us. It's from 9 to 3, not 12 to 3 and 4 to 6. But the court said, wait a minute, take a look at the individual child and this child's particular circumstances. He just can't be there in the day, and you just can't simply say he's got to come to the water to drink it. In this case, you've got to adjust the trough so that he can drink in the later afternoon. And so this parent had a major victory here. we move on.
And I think, Perry, you bring up sort of the so what of the IEP. And I think that's what most of us really think about in terms of when we're developing this document. Is it going to be a vehicle that's going to help this student make progress within their IEP goals and their general curriculum? And as you saw in the video, when we think about this substantively appropriate IEP, there are some basic things that we're learning. A lot of the IEP monitoring activities look at the compliance of the individual parts. But what really is meaningful is whether the PLAF statement justifies the statement of services and aids. And that's your special education, your related services, the supplementary aids and services, or like the last example that Perry shared, a program modification that's essential for the student to fully access what we consider to be the general curriculum. The other thing, oh, go ahead.
Before you leave this slide, by the way, I can't hesitate just to show again the difference between this sort of adjudicative legal view and the actually better, higher level of the professional view. And that is in my recent or ongoing update of a representative sample of procedural FAPE cases, I found, contrary to what you're doing here and contrary to the literature in special ed, that the PLAF component hardly came up at all. In the 99 cases, it was only challenged twice and neither was successful. So from a legal view, the PLAF statement doesn't seem all that important, but that's again, because that's the way these old judges like me might look at things legally. Nevertheless, whether judges look at that frequently and use it as a foundation, as a matter of best practice, if that establishes the kind of collaboration with parents and progress ultimately, don't lower yourself to the court's view and end up saying, no, we're putting our priority here. But that's a discretionary choice of schools, state departments, and parents that we hope will be moving to the direction of best practice rather than merely with how the courts might view it. Thank you.
And I think, Perry, this is what we see in implementation, because the PLAF doesn't seem as cool or doesn't seem to be the thing that gets the most attention in monitoring. There tends to be an over focus on the goals and the services. And then we get questions of, but I don't know what the goal should be, or I don't know what services the student needs. And ultimately, what helps us make that decision is the PLAF statement, because it clearly outlines the disability-related need that requires special education. And if it requires special education, then it requires an IEP goal. And I think that refocusing on the PLAF, for one, brings the whole team to really focus on the child, and it allows the team to more feasibly develop all of the other parts of the statement, whether it's the special education that's going to help the student progress on their IEP goals, the monitoring plan that's going to help you monitor the goals, right? All of those pieces within that IEP should make sense, because what we're offering is one program, right? An individualized education program. And we received an anonymous question, and I think it sort of leads to this slide as well, as, you know, what is the purpose of that program? This is also something we're sort of seeing from a best practice, is in those schools in which kids are making sufficient progress, there is not just an overfocus on the annual goal. And if you look at this graph here, we've spent the last 5 years trying to sort of tease out, what does it mean for a student to experience progress in school? We in special ed often focus on, is the student making progress on an IEP goal? That is a very narrow indicator of progress, right? It's addressing those disability-related needs that are preventing the child from fully accessing and benefiting from the general curriculum. But as Perry mentioned at the very beginning, really the intent of special education and the development of the IEP is for students to access and progress within the general curriculum, which includes your academic and non-academic activities, your extracurricular activities. In a sense, is for them to be able to experience school like all of the other kids within that setting. So in the question that we received is, if I have students who are physically sitting in the classroom, but are being excluded from the general classroom assignments or tests because of their disability, or because we think special education is the outcome and not the vehicle to help the student progress, we could be potentially denying them FAPE, or at least preventing that child from making appropriate progress within that school. Because the way that we as society look at progress is, are they performing on those national accountability measures, graduation, post-school success, right, or our state assessment? The student is not going to be able to have the same opportunities to experience success there, and thus will have a harder time experiencing post-school employment, post-school education success, and in some cases, independent living. So some things that we have found from the research and from our work is that really we have to move sometimes the IEP document to the side. And I'm sure all of you are thinking about how you've run your last meetings. Maybe you display the electronic copy up on the screen. But when we do that, our focus tends to be on the document. And that moves us back to that procedural side. But really what we want to start out an IEP meeting is understanding the child and the needs of the child, and ensuring that everybody is meaningfully engaged in that process. The IEP is really sort of the final document that, the procedural piece that puts down everything that we agreed upon in a nice, clean document that gets shared with the parents as well as other educators supporting the implementation. The other thing is, when the team, as a team, not just the special educator or the facilitator, but when that team finishes, that they have this reflection process and say, hey guys, did we address all the needs that were outlined in that PLAF statement? Are we sure that all the goals that we proposed in services address a need that this child actually has? And do those proposed services justify the location of services? I know we have a question later about LRE, right? And if we were to deliver these proposed services in this IEP, do we believe that it's reasonably calculated to help the child progress on those IEP goals, as well as within that general curriculum? So Amy will share, I think one of our best resources that we've seen is, this is around looking at the internal consistency, or what we often think about as a substantively appropriate IEP. It's a very high level process. So if you're teaching in a university setting and you're looking for a great activity, or you're providing PD from a state monitoring or a local education PD provider, should be like a go-to resource, because it takes your IEP, helps you, sort of identify the individual needs, very simply using a different highlighter, and then look at the internal consistency between a need that has been identified in the PLAF statement, and do you actually have a proposed aid service or modification within your IEP that addresses that, right? That increases that, yeah, I think it's going to be reasonably calculated. And then we would look back and also say, well, is the IEP goal going to help us ensure that this student is progressing towards those, is the special education that we propose going to help the student progress towards those annual goals? Now, I know we don't have a ton of time, but I want to make sure that we get into the implementation piece of this, because we can develop a great IEP, we can meet all the check boxes for that, but really the effect size or the benefit that we provide to students comes down to whether we actually implement those services to produce the proposed benefit.
And so when we look at implementation, which once again, courts are sort of slow in picking this up. So although from a lot of people in reality and best practice, this should be sort of the starting point. Are we delivering what we've promised? But courts have only gradually dealt with the test or standard at a legal level for adjudication as to sort of how much implementation is required at this minimum level. And for the adjudicative route, the various courts have tended to agree that, again, not like best practice, because from a best practice should point of view, I think most would agree that if you're not implementing the IEP for whatever reason, and maybe a very good reason, that the teacher has been sick for the past 2 weeks and you haven't been able to find a replacement that has her credentials that this child needs, regardless of whether it was a material discrepancy, one would hope that you, as a matter of trust and professionalism, would offer to the parent, how can we make up for or compensate voluntarily to stay on an even keel in terms of when we say something, we are going to deliver it. And if there is some legitimate reason we haven't, we will make up for it. But again, minimum for courts, they're saying the discrepancy or shortfall between what the IEP says would be delivered and what actually happened during the school year, that shortfall has to be material, like a material breach of a contract. That would seem, I would think, somewhat ambiguous to most of us because we don't use this adjective or noun material or materiality that often. So more specifically, just go back to that slide for a second. The hearing officer or court must find that the district failed to implement the IEP to a material extent, which may be, depending upon the jurisdiction, either qualitative, like qualitative compensatory education or qualitative research. And that in the Fifth Circuit, which includes Texas, would be a major case called Bobby R., where the court said, first of all, the discrepancy must be for a significant or substantial provision. Is, let's say, Orton Gillingham, if that's what's specified in the special education, is that, or is speech therapy, is that a significant or substantial provision? Or the quantitative approach, which looks sort of as a proportion or a percentage. Is the percentage that is the discrepancy 10% or 20% or 40%? And anything more than minor would be a material breach. So the Ninth Circuit, that's the far west, has one approach. The Fifth Circuit has another. And finally, when we're talking about progress, progress is a optional criterion here, and you'll see it in a minute when we get into the cases that we can do quickly because of time. Oh, but before we go to the cases, we are reminded again, the state complaint process and the monitoring process do not necessarily use this materiality standard. They can use a more strict standard. So again, you have to be looking as a matter of sort of risk management as to how it works in your particular jurisdiction. But let's look at a quick sampling of cases. Spring Branch, the Fifth Circuit, using that Bobby R. qualitative test, ended up saying that for this kid, timeouts, which had a restriction in the IEP, that the violation by far more frequently using timeouts than the IEP said would be the maximum, and also cutting the kid's day in half because of this kid's behavior, sending the child home early or coming late, etc., without going through the regulatory process for an amendment, which I might regard as procedural FAPE. In this case, the Fifth Circuit said those two things were both material discrepancies because they were significant provisions for that kid, and they resulted in loss of progress, which is that optional feature, and thus there was a violation. Abigail, and one of you asked about remote instruction. Well, this was during COVID-19, but even though it happened in the year 2020 or 21, it didn't get to the Third Circuit until 2024, and the parent said, hey, the specially designed instruction, that is SDI, as well as the related services, in this case, there was a discrepancy. And the court ended up using a combination of the qualitative and quantitative, and ended up saying that in this case, it met the standard. I'm sorry, parent, as a matter of, again, what should have been done in terms of providing these services is one thing, but what the court required here, so this was a parent loss. And then finally, and most recently, and I think some of you will find this to be particularly relevant because we're no longer dealing, at least nationwide, with COVID as a pandemic, but we do have a pandemic of shortage of special ed personnel. And in this case, the district, when you read through the facts of the case, I mean, in terms of the special ed teacher, the aides, the turnover, the speech therapist, the substitutes, it was a mess. But the point is that the district nevertheless said, wait a minute, it's not our fault. It's the staff shortage. We advertised the position. We went to conferences. We did whatever we could, and we couldn't find a person to fill these various slots for months. Well, the court ended up saying, just like the pandemic, FAPE is FAPE. It's an obligation, and it's not a matter of fault or blame. It's a matter of, did you deliver or did you not deliver? And in this case, the facts were clear that there was a substantial shortfall, either quantitatively and or qualitatively. And this court ended up saying you get comp ed for the period before this parent just got so frustrated that she unilaterally placed the child elsewhere. And once she did place the child elsewhere, you also owe tuition reimbursement, plus, again, attorney's fees.
And as we close up, I think this is where we have to think about the best practices. It is inevitable, I think, as Perry mentioned, that we're going to experience circumstances where we're not able to do that. We see this sometimes with assistive technology, where it takes a long time to procure the funds for that, to get it set up. And so even though it's in the IEP, the kid may not actually get full access for 3 months. So part of that is, you know, making sure that we're engaging families as soon as possible to identify, you know, what are some of the potential concerns that we might have in implementation, and how can we address that, and maybe proactively provide some of that compensatory services, as opposed to waiting until it becomes, you know, a due process issue. Some other things as we close up today is, you know, this idea, and I'm going to point out the very last one, is right now, we're finding that in IEPs, we are seeing people focus on what their service delivery model will be, as opposed to ensuring that the IEP focuses on the services that the student needs. The service delivery approach that an LEA uses can be flexible, right? That's on your side as an LEA, how you choose to implement those services within your IEP. And you can leverage your existing resources, infrastructure like your MTSS, your intervention blocks, to ensure that the student has full access to their SDI, as well as the general curriculum like other students. And one last thing I would say is that we have found, you know, one of the challenges at the local level is people aren't clear about what their roles are in terms of implementation. In some cases, we see that general ed believes it's special ed's responsibility to implement that, but in reality, it's the LEA's responsibility, which includes the general education teacher, the related service providers, and the special educator all have a role in ensuring that IEP is implemented. And if that team doesn't feel like they have the knowledge and skills to do that, one really cool thing about your statement of services and aids that you can include in an individual kid's IEP is supports for school personnel. And so if you're not familiar with that, we'll share a little bit about that in the open Q&A that follows. But we wanted to make sure that you are aware that there are some evidence-based practices that are beyond what we often think about as fidelity. Fidelity is part of it, as Perry mentioned. But it's really around building our capacity to be able to implement that. Even when we have new teachers or teacher turnover, we're still obligated to provide those services that are outlined in the IEP. So we'll summarize here in a second. I just want to share that we did put the evaluation that's in the chat box. We'd love for you to take some time and fill that out. We're going to leave open the conversation, but we are going to turn off the recording for our open Q&A. You are free to put some of your Q&A in the chat box or in the Q&A box, but we already received quite a few questions that we will address right from the onset. But as we're transitioning into that open Q&A, please take a little bit of time to complete that evaluation. So Perry, as we close up, I know we're a little bit over, and if you all have to drop off, feel free, but I want to make sure that we formally close up here. So do you want to address the first two real quickly?
Sure. And so again, if you were listening to me, there is some ambiguity, but in general, it's quite clear that whether you're addressing procedural FAPE, substantive FAPE, or FTI, failure to implement the IEP, the courts give you a lot of flexibility. They have a more relaxed and district deferential standard. And my view is, number one, going to the second paragraph, but don't forget about the state complaint route and the state education agencies monitoring process, which may well be stricter. But more importantly, as you turn to the third paragraph and look back to Tessie, my view is use that flexibility not to reduce yourself to the legal level, but for the discretion to make wise choices about resource investments with parents that produce progress.
And we'll address a lot of these, and we've had some great questions coming in the chat box. But I think, one of the things that I think you heard Perry clearly push and myself is that the professional best practices provide the opportunity for this student to have the greatest access and potential for progress within a school opportunity. The procedural is more about meeting sort of that bare requirement. And I think about it like your child sort of cleans their room. They picked up some stuff and they shoved it in the closet. The room looks clean, but really what we're looking for is really for it to be substantive, right? That it's clean all over for the student to be able to be successful. So we've shared the eval in the chat box, and I'm going to leave this up for a second. We will be offering a number of free opportunities for folks. We've shared free learning modules, resources, tip sheets, everything that you need to be able to, move some of this conversation into your local audience or your local context.